Good afternoon, welcome. Thank you so much for joining us in person and online at the launch of the latest in our series of research reports that explore the benefits but also address the limitations for the protection of rights in Northern Ireland as a result of the Windsor Framework, Article 2, previously referred to as the Protocol for the technicians amongst us. Once more, we are delighted you're with us and so pleased to be able to harness your expertise and experience and share what we have with you. We are all in pursuit of a shared objective, which is to protect rights for everyone in Northern Ireland. We're here to discuss the rights of asylum seekers and refugees, and in particular, how we can protect them. The timing and focus of this work could not be more critical. We know that human rights are worth little if they're not enjoyed universally. We also know that asylum seekers and refugees are some of the most vulnerable in our society, in fact, across the world. They are our fellow human beings who have suffered a great deal. Those who've come to Northern Ireland have become our neighbours and friends. We should treat our neighbours and friends well. We must not turn our backs on or denigrate those who seek solace amongst us. It's especially fitting that we are here at Clifton House with its proud history of welcoming and supporting vulnerable members of the community. This week's Supreme Court judgment marked for us a moment of relief at a bleak time. It signalled, as if we had to wait for this, but it did signal the supremacy of the rule of law. And any argument that it did anything other than that is disingenuous and a retreat from universal human rights which value democracy. And while listening to the judgment, I was struck by the lovely simplicity of it. What they said was law matters, international obligations matter, evidence-based truth matters. And a key point was that judicial integrity and independence means that evidence must be tested by the courts. If a court has to decide whether people are at risk, they will do so carefully. Promises are not enough. Even government promises can be broken, so more is required. And the court's recognition of international standards and, I quote, unique and unrivaled expertise of the UNHCR stand in stark contrast to the proposals, which were made in apparent disregard of the evidence. The judgment also contains some helpful observations in relation to EU asylum law, which bound the UK before Brexit, and in our view continues to set standards in Northern Ireland through Article 2 of the Windsor Framework. That brings me to today's research. Windsor Framework Article 2 is the UK Government's commitment to ensure no diminution of certain rights and safeguards in Northern Ireland as a result of Brexit. It means, in essence, that certain EU measures continue to set standards below which the law in Northern Ireland cannot fall. It also means we have to keep pace with any changes that strengthen certain equality protections. Appreciative as we are of Article 2, it raises complex questions in terms of its nature, scope, and operation. And for that reason, the Commission continues with its extensive research programme. In doing so, we're very keen to build relationships, share experience and expertise, and develop a real community who will understand and tackle the challenges that we're now facing. Early drafts of today's paper on asylum helped to inform and shape the Commission's thinking on the extent of Article 2 and assisted our parliamentary engagement on the then illegal migration bill. And that set us up well to consider fully and then decide to challenge the Illegal Migration Act as contrary to human rights and the rule of law. The hearing will take place at the end of January. We already have permission to proceed. So given the setting of the Windsor Framework, a critical question that runs through all of our research is the breadth of the Belfast Good Friday Agreement's chapter on rights. We need to know, first of all, who is protected. And Alyson's piece on trafficked persons, which we launched last year, also, as well as this piece, addressed that. Secondly, to what extent can we rely on the broad commitments in the agreement that a wide range of EU law continues to provide a benchmark for Northern Ireland? Alyson's research also grapples with that and the more esoteric, or at least to me, UK opt-ins and opt-outs as regards the common European asylum system. She had to judge where that leaves us after Brexit, and she's done that in this research. And I have to say, I'm particularly grateful to her because she's had to return to this a number of times and showed great patience and resilience as things developed. She had 2 papers to share today. The second was commissioned in response to a set of questions about the degree to which migrants can rely on the protection of Article 2 at Windsor Framework. I know I have many questions, few answers of my own. So I'm delighted to have the support and expertise of the team at the Commission, only some of whom are here, but we could not do any of this without them. They truly are the experts on the Windsor Framework. They're working closely with others to develop their expertise across all the sectors and topics. So this sort of collaboration is so important. So the important person for today's perspective anyway is Alyson Harvey, who I have the pleasure to introduce. She's a practicing barrister, a specialist in matters of nationality, immigration and asylum. She is the author of and contributor to many books and articles on immigration law, including A Guide to the Immigration Act 2016, along with Zoe Harper. She has contributed to McDonald's Immigration Law and Practice. She trains, lectures and writes widely on immigration, asylum and human rights law, including for the Immigration Law Practitioners Association, of which she was General Secretary and subsequently Legal Director. So she's certainly qualified to help us in relation to this work, and we're very grateful to her. So I'd like to introduce her to you and ask her to present her paper.
Thank you very much. Alison started with the Rwanda judgment, and I think that's a useful place to start because it came out last week. Clearly, it is very depressing when the highest court in the land has to phrase a judgment in terms of anticipating a right-wing backlash led by ministers. So that gives you a chill, I think, when you read the judgment. Having said that, they rise to the task admirably. They certainly don't put all their eggs in the European Convention on Human Rights basket, but look to international customary law for the prohibition on refoulement and determine that within the standards of international law, including the Convention on Torture, Rwanda is not a safe country, which produced the response from the government, then we will make it so, just like Humpty Dumpty, by passing a law that says it is, and redefining the meaning of safe. There's since been a backtrack from that position. There's an interesting second part to the Rwanda judgment where there was an argument about whether the EU Procedures Directive formed part of retained EU law. It's the sort of judgment, the sort of argument that gets characterised as interesting, which is not always a compliment to your arguments. And the court concluded that it did not form part of retained EU law. The argument was that the repeal of items of retained EU law only bit on free movement and immigration, but not on asylum. That argument failed. But that gives extra weight to the importance, the potential importance of Article 2 of the Windsor Framework, because if a matter is retained EU law, we don't need the Windsor Framework. It's still part of our law throughout the United Kingdom. If a matter has ceased to be retained EU law, then we become interested in whether there are special protections for it in Northern Ireland. I commend to you the judgment. I do think everyone should read it. It's incredibly clearly written. It's a very good primer on the issues that are clearly going to haunt us for some time to come. Alison mentioned my paper on trafficking, which was published in March 2022. And by that time, this paper was already envisaged. That was at a time when we were just coming to the end or in the middle of last year's Nationality and Borders Act, and no one had even thought of the illegal migration bill. So the paper has been through several reiterations as the government has become, shall we say, more ambitious in terms of what it can do to push back against international human rights standards. The other thing that has changed is the Commission's working paper on the scope of Article 2, which was very important. When I started, I said, where's the list of what the Commission thinks is included in the equal rights part of the Good Friday Agreement? And everyone said there isn't one, which was rather frightening because immigration isn't the obvious place to start in creating one. That's so often the case. We are the most dangerous place to start because the political backlash will be heaviest. But we are also the place where you consistently end up starting because we've got nothing else. We've got nowhere else to go. The only people who beat us to it in that respect were the Society for the Protection of the Unborn Child, who also had nowhere else to go and called on EU law and generated the first judgment about Article 2, which everyone will have seen, where we heard the conditions for its application. So as this paper developed, thinking on what was within the scope of Article 2 was also developing, and so was the law. The first point that I've set out in the paper is that clearly Article 2 protects the rights of everyone within the jurisdiction. There is an argument as to whether it goes wider than that, given the obligations the parties have taken on to any other people, but from our point of view, everyone who falls under the jurisdiction of Northern Ireland law is encompassed. Asylum seekers, refugees, people whose claims have failed, who remain on the territory when they have no permission to be here. They are encompassed, and that is not controversial. That's been accepted by the government most recently in the AA case. It was accepted by the government in its explainer on Article 2. So I was not saying anything radical there. But the idea that if something affects persons seeking asylum, then it is going to be part of the rights protected by Article 2. And that is not at all surprising, because what the Good Friday Agreement was designed to do was to ensure a certain type of society, and to ensure that if the people of Northern Ireland took a vote on whether they wanted to be part of the UK or part of Ireland, then that vote wasn't going to be constrained by fears that in one of those societies, some of them would be without protection of their basic human rights. And of course, the laws on immigration go far wider than affecting persons subject to immigration control. They affect their spouses, their partners, their children, their employers, the people who wish to sell them goods and services, all across. What you can and can't do, whether it's driving someone in a taxi or employing them, is affected. So it's not surprising that the protections should encompass all that people. Now, the EU law applicable to the UK, potentially retained, is an extremely complex matter. It isn't easy to understand because the UK, ever since the time of Mrs. Thatcher, had negotiated opt-outs in the field of border control, as had Ireland, and it could opt in and out at will of different parts of this. So we didn't keep pace automatically with the rest of the EU, and in particular, when the main directives were recast, we didn't opt into the recast directives. So we were bound by the earlier version of the directives. There was a point at which the government tried to argue that we weren't bound by them either, but they pretty soon gave that one up as a bad job. We were bound by the earlier versions of the directives, while most of the new jurisprudence was about the new versions. At the same time, because we opted into the most recent iteration of the Dublin II regulation, which allows you to move people seeking asylum between the countries of the EU, then we also ended up importing little bits of the recast directives that are built into into Dublin Dublin only works if you apply some of those. So it's a very complicated jigsaw, and it goes far beyond the directives that we associate with the asylum acquis to the broader underpinning of instruments such as Eurodac on the fingerprints and the identity databases. And there was some really fast, as I've detailed in the paper, opting in and opting out on the very eve of Brexit. When we knew we were leaving the EU, we were still opting in to some of these instruments at the 11th hour. So it leaves a complicated jigsaw of rights and obligations that you have to negotiate. And it's important to remember the EU has never been the most migrant-friendly jurisdiction. Its asylum procedures have always had one eye on what you do with people when their claims fail and with border management. And that's very much a part of what it does. So when we're looking at the rights, sometimes we will think, well, that standard has dropped since Brexit. But then when we look closely, we realise that EU law never did demand the higher standard that the UK was applying. So it doesn't help us a bit that we've now dropped down. The other important area to remember is that you've only lost a right if it wasn't guaranteed by other means. And the most obvious is the European Convention on Human Rights. If your right is protected by the European Convention on Human Rights, why should you see a diminution as a result of Brexit? Because at the moment we are still part of the European Convention on Human Rights. And the answer there is that you are most likely to see a diminution in the procedural protection, in the means of enforcing your human rights, in what the government must do. The most conspicuous example of this is in the field of humanitarian protection. So we are clear that the Refugee Convention contains the obligation of non-refoulement and makes a series of demands. The European Convention on Human Rights had no prohibition on non-refoulement on its face. That was read into Article 3 of the Convention in the Söring case, which was the case of the extradition of a man to face the death row phenomenon in the United States. At that time, the European Convention on Human Rights still had exceptions to the prohibition on the death penalty, so it wasn't that Mr. Söring might eventually be executed that was the problem. It was the years he was going to spend on death row that led the European Convention on Human Rights to say you cannot send a man to those conditions. So what we had there in European Court of Human Rights law was a stark prohibition on refoulement, but none of the backup. What status would you get? What rights would you get if you were someone who couldn't be removed? Did you just sit there in limbo? Or did you have a right and status? So there, the European directives were incredibly powerful in fleshing out the rights of people to family reunion. Similarly, the Refugee Convention makes some nice noises about family reunion, but it doesn't create any binding standards. You can get some of those binding standards out of human rights law. You can get some of them out of Article 8, but you won't find anything there about how you give effect to those. And you have to look to the European instruments, still weak, but not as weak as the Refugee Convention. So the first thing that is going to be important in seeing what Article 2 can do for asylum seekers and refugees is to get really clear on what rights people had before Brexit. Don't assume that we lived in a sort of happy land where people's rights to asylum were completely protected. One of the recent controversies was the question of a social group and the definition of a social group, that they had to have a shared characteristic. And we used to say, or be recognised as separate in society. But the European directive didn't say or, it said and. It said they had to have a shared characteristic and society had to pick them out as a group in some way. The UK never applied that, and I've gone into details about the Supreme Court judgment in Fauna that said quite rightly they didn't apply it. But when we lower that standard, we can't say we lower it back below EU law. We've also got the problem of EU law freezing at the moment of Brexit, save in those areas where it's progressive. Now, you might get a judgment post-Brexit that says what the directives meant pre-Brexit, but that's, please don't take photos of me when I'm talking, I can't bear it. You might get a judgment post-Brexit, but that judgment is very likely to be about the recast directives, not the original one. So working out whether it has any implications for the interpretation of the original directive by which the UK was bound is likely to be a matter of some complexity. And that's partly what we have to grapple with. What is good about the October judgment in the AA case is that it makes clear that the standards in the Charter are also part of what must be taken into account. That was always a question because, of course, the Charter was the first thing the government said it was ripping up when Brexit happened for the rest of the UK. The Charter was always only supposed to codify those obligations that existed elsewhere in European law. You were supposed to be able to find them all somewhere else. But nonetheless, it's much neater. And anyone involved with the asylum system at the moment must have their eye on the right to good administration. Not least because working out what laws do apply in any part of the UK and what is retained EU law and what is not has become such a matter of complexity. So knowing when you have to reach for Article 2 is such a matter of complexity. We have, in the Nationality and Borders Act and now the Illegal Migration Act, forays into all sorts of areas that are not simple questions of refoulement. We have the question of whether you're treated as a child or not. We have the questions of how trafficked people are treated, the procedural guarantees for how they are protected. And I believe it is in those procedural guarantees that we are most likely to find that we are turning and saying standards have been reduced since Brexit. So that is what the paper aims to take you through, to sort out which rights are affected in a detailed and forensic manner, and then to look at whether those rights have been diminished through Brexit. And we find that in Part 7, an examination first of the general types of rights that might be limited in 7A, and then the details of the rights in 7B. So one very interesting area, for example, is temporary protection, because the Temporary Protection Directive was considered a dead letter in EU law for many years. None of us spent much time reading it because we all said it was put together after Kosovo, but no one's ever going to use it if they didn't use it for Syria. Obviously, it's a dead letter, because if ever there was a case of large numbers of refugees being accepted into the EU in situations that looked as close to a mass influx, that was it. Then along came Ukraine, and suddenly it was back on the cards, and the EU states did start applying the conditions of the Temporary Protection Directive. So much has moved in the time that has gone through during the period when this report was written. We are still waiting to see what the Illegal Migration Bill Act will look like. In practice, a lot of its provisions aren't yet in force. They don't yet have the enabling legislation. There will have to be a rethink of some of them after Rwanda, unless the government does move very quickly to say it's safe, but that's just going to set off a whole new area of legal challenge. What seems likely, if the government has its way, is that we will have a large group of people in limbo whose claims have been declared inadmissible, but who can't go anywhere because Rwanda never promised to take a very large number of people. Those people in limbo will suddenly touch on some of the other rights that are protected, the questions of rights to liberty, the questions of the social security acquis and what is kept there. And looking at those rights, someone is on the territory, they cannot go anywhere. The government says they could leave voluntarily, but they're not. What then are the range of obligations towards them? And that is likely to be another very powerful area of challenge. Probably easiest if I leave it there and invite questions from you, I think.
Also beautifully simple, if you don't mind me saying, something that otherwise is not. I think one of the things that comes across with a lot of this work is that the question of status, a person's status, it's almost visceral. It's so much more important than what you're called legally, but that is also very important. And I think what we need to remember is that the traditional communities in Northern Ireland do not benefit from the Good Friday Agreement unless and until everyone with their feet on the soil here benefit from the Good Friday Agreement. You can't single people out. It's either fundamental rights, in which case everyone has them, or not. Now, enforcing them, that's not necessarily simple, but as a matter of principle, it's got to be that everyone shares the same enjoyment of rights. So, questions? Who would like to go first? Someone has to break the ice. There we go. Thank you, Colin.
Okay. Just want to commend the Commission and Alison, both Alisons, for this another impressive piece of work, emphasising again the point that's been made about the protection of human rights for everyone here, and particularly good to see a focus on refugee and asylum seekers. There are two questions really, which one addressed to the Commission and one addressed to Alison in terms of the paper, and they're more by way of reflections, because I'm, like a lot of people in the room, working through the paper. First, to the Commission, the UK government's currently involved in a secret negotiation with one political party here in relation to the Windsor Framework and other matters. And a question to the Commission would be, has the Commission been given any assurance or any information as to whether they're going to leave Article 2 alone? That's a question around that, because obviously many people have focused on the trading aspects and all of that, but there'll be an obvious worry here that nothing that will be done in those negotiations to undermine what we're talking about this afternoon. That's the first question. And the second one is really just, Alison, probably both practice and sort of academic point. Obviously, immigration and asylum, an accepted matter here in terms of devolution, and one of those things that the current government particularly protects very, very carefully as part of its both its politics and its rhetoric. But I wonder to what extent does Article 2 open up a big question around immigration and asylum law in the future? in terms of the obligations that it will require to apply in Northern Ireland as distinctive from other parts of the UK? In other words, as this evolves over time, to what extent do you see almost some of those very, very fundamental old arguments about the nature of immigration and asylum being accepted, central to Westminster, being undercut, really? In other words, in order to comply with this in the longer term, how sustainable will that be? In other words, will we have to think differently about immigration and asylum in a Northern Ireland context in the future? Thank you.
I'll take the simple one first. Unless somebody's going to correct me, and we've received something in the last couple of days, then we have been assured that Article 2 is not controversial, but that's not the same thing as being assured that it's not going to be affected or undermined or indeed repealed. And I do fear that it's, whether or not it's seen as controversial, may be affected by, for example, using it in the Illegal Migration Act challenge. So I don't think we've been given any greater assurance than that, have we? Other than it's not that they're not concerned with it and they intend to keep it, but that's as far as it goes.
I think you're right, because it is significant because of what is going on in Westminster. We are seeing a dive below standards that have been recognised by a large number of countries, and we're seeing a dive below most basic standards that found their reflection in the EU instruments because they were uncontroversial at the time. So the idea that you could only return a person seeking asylum to a country with which they had a connection was not particularly controversial. Suddenly it is. And the idea that if your life and freedom is not threatened in a country, we can pick a country. The only thing that matters is that they will take you. That's a novel idea. That's not to say that other states aren't pricking their ears up and thinking we'd like one of those, and may bring that to the negotiating table in the EU and try and renegotiate the European instruments in that way. But at the moment, what we saw in the Nationality and Borders Act was arguably the current trend taken to its extreme. The illegal migration bill is something different. That aims, for a start, it was written with, on its face, a statement that it was not compatible, potentially not compatible with human rights. Ministers couldn't sign it off as compatible with human rights. That was a new departure. We've always been told through bill after bill, some of them appalling, we love refugees more than you do, we're only trying to protect them, this is the only way to protect them. This one said, actually, we don't like refugees very much, and we know they're having a bad time, but we'd rather have few of them. The only country I think we've really seen do that before was Australia. And I remember many international meetings in Geneva when the Blair government was there passing all the support legislation saying, no, it's because we love refugees so much. And the Australians were essentially saying, we're bastards, we don't care. And you realised how much hypocrisy is the space in which we work when we're working with asylum seekers and refugees. And if you take that away, it can be very difficult. So the illegal migration bill didn't pretend that we liked refugees. It says just we knew these people need protection, but really we can't give it to them. We have other things to worry about. They are in the way. They can't come here. So yes, I think the European model at the moment still looks traditional. The European model is tolerating some pretty extreme behaviours from Poland and Hungary, and we're only just seeing the EU try and find its feet as to how it's going to deal with very, very extreme regimes that are, in theory, within the EU system. So yes, I think potentially Ireland will have to have a very different regime to the rest of the UK, and that raises questions very controversial in the context of Northern Ireland about internal movement. in the UK. Because once you are a refugee in the UK and recognised whether through a system that applies in Northern Ireland or a system applies in England and Wales, you are free to move where you like within the country. And that has huge implications if we are seeing people recognised in Northern Ireland who then go to Liverpool or London, who would not have been recognised had they claimed in Liverpool and London. That will raise interesting questions. You know, it's not easy if you're an asylum seeker to get on a plane from London to Belfast. You try finding a document that will satisfy the people at the airplanes. But if you could do it, then potentially you could bring yourself into a different regime.
I'm going to pick somebody out of the audience if you don't volunteer. Or we'll move on to the discussion. No more questions? I told you it was beautifully simple. I think everyone also wants to digest. Oh, here we have one. Go ahead.
Thank you. Is your reading that asylum seekers who have yet to arrive could potentially be encompassed, or only asylum seekers who were here prior to December 2020?
Those who've yet to arrive, because, as I say, the obligation to treat people under immigration control in a particular way is an obligation owed to all the people of Northern Ireland in the context of the society in which they wish to live. Those people may be the family members of people in Northern Ireland, they may be people who will come to work for people in Northern Ireland who live there. Absolutely, if you have an obligation to be the sort of society that treats people seeking international protection in a certain way, that is an obligation you owe to all your citizens. And the people who benefit from it are the indirect beneficiaries of the obligation to your citizens. So there's no question of a cut-off. And in the more classic migration context, that's also been a question, because when Brexit was happening, all eyes were on the stock of EU nationals, the people who were here. The biggest implications for UK businesses and so on were always the flow of EU nationals, the new people they would want to bring in to work from them. And obviously the stock were here, they were people's neighbours, friends, school fellows. They got all the attention. But the real long-term damage has been that you can't bring your partner in, that you can't bring your employee in. And in Northern Ireland, that's where you look and you say, but the obligation to people in Northern Ireland was to ensure that they were no worse off. Now, in the case of migration, because we'd exercised so many more of our opt-outs, there weren't great rights for migrants. So it's a far more limited means by which you can prove a diminution as a result of Brexit. But the same principle applies, that when you can, the obligation is to all the people of Northern Ireland. It's not an obligation in particular to the immigrants themselves. They're within the jurisdiction, but they're not the only beneficiaries.
Just to add to that, I think what Northern Ireland learnt and what was at the heart of the Good Friday Agreement and the way it incorporated the ECHR, etc., was that the lesson that when you distinguish between people and create any other category when it comes to fundamental human rights at least, very quickly human rights are violated in the case of everybody. So even if you don't care about the others, if you care about yourself, you protect the others. And I think that's something that we've learned here, and maybe they need to pay more attention elsewhere to that. If we don't have any more questions, oh, we do have one. Yeah. Sorry, one sec.
Oh, sorry, I beg your pardon. Thank you so much for the work. And forgive me, I work in the devolved government here, giving legal advice. So I'm not directly involved in immigration and asylum issues, but Article
Just
2,
making that clear.
Article 2 tortures us in all sorts of ways. So, and one of the issues fairly obviously is divergence as to what may happen in GB and what may happen in Northern Ireland. So just to be clear, from my reading, so there are two big issues. One is everyone, and what do we mean by everyone? And I think I haven't had a chance to read Angusum yet because it's not published, but I think you were saying that Angusum now says that includes asylum seekers. Is that correct? So if
that's also what the government said in its explainer. So it was no surprise. My reading of Angusum is that the parties agreed, the court agreed with them, but there was no party putting the case that it didn't encompass them.
And then the second one is in and around civil rights in the kind of introductory bit to the enumeration of the rights in particular. So did Angusum say anything about that, which is of, I'm sure I'll find when I do actually get my hands on the judgment and able to read it, but did Angusum help us at all in terms of interpreting that?
My memory of Angusum, and I'll be corrected by someone in the Commission if I'm wrong, is that in the particular case, it found no diminution of the right, and the right wasn't covered. But the idea, the general idea that we go broader than simply paragraph 1 of that part of the Good Friday Agreement is implicit in the judgment. So I think the work that the Commission has done in its paper on the scope of Article 2, essentially, to me it seems absolutely uncontroversial that all the ECHR rights are in there. And the broader rights that everyone has recognised, such as the Victims Directive. The Victims Directive is a good example because the government has agreed that the Victims Directive is part of the protection that is covered by Article 2. But there is then a question where some people will say, but it only means the victims of the conflict in Northern Ireland. And you look at the Victims Directive and you look at Article 2 and you think, well, there's no limitation anywhere I can see. If you have victims of conflict, this directive applies to them. Having said that, if you look across the EU, you won't find much mileage has been made of the Victims of Directive for victims of torture and so on. So you're not going to find a body of jurisprudence, but the pure legal argument seems very clear. So I think that essentially it's shaping up to say the procedural protections are going to be particularly important. As the Rwanda judgment shows, you can find the broad, high-level protections in the European Convention on Human Rights and indeed in international law. What the EU very often did was say how you would avail yourself of those rights and how you would be put in a position to be able to assert your rights. And it is there with those things that were part and parcel of the rights, but not actually spelt out in the European Convention or the international instruments. It's there that the EU law is going to bite. It's also the case that the European Court of Human Rights style on asylum and immigration tends to be quite high-level general pronouncements, not least because within the Council of Europe there are a huge range of countries with very different asylum procedures. Whereas the European Court of Justice has got far more down and dirty into the detail and the particularities of situations. And Professor Elspeth Guild and Nuala Mole of the Air Centre have written a lot about the dialogue between the two courts and the way that they look over their shoulder to each other's judgments. The other paper of mine that's around today is an analysis of the rights and equality provisions in Northern Ireland after Brexit, where on migration it's quite a depressing story because the European Court of Justice, like our own courts, has always been thoroughly depressing on the question of discrimination against migrants as opposed to against particular people of particular race and ethnicity, very bad, and the protection is therefore very limited. But those are relevant arguments, I think.
On the victims' point, if I can add just a general one. In my reading of it, the Belfast Agreement cannot have been intended to be limited, and neither could what now is Windsor Framework, to victims of the conflict, because, not least because the Good Friday Agreement was about the future. If we've learned anything recently, it was never intended to be reparation for the past, and certainly isn't reparation for the past. So this argument that it was intended to sort of stop at a certain point and only cover victims of the conflict, I think is very disingenuous. But I think that takes us to the end of the questions. We now have, with perfect timing, we now have a discussion. We're going to introduce our, I'm going to leave it to my colleague Htaik in her very capable hands. She's going to take over the panel discussion, and we have four. We have four, yep. I haven't miscounted you all. We have four very interesting people. Unfortunately, I can't stay for this bit. I'm really disappointed to have missed it, but I'm going to be briefed at the end of today. So thank you all. And can we thank Alison again before I leave?
Good afternoon, everybody. My name's Htaik. I'm a solicitor at the Commission, working in the dedicated mechanism, and I'm really delighted to be chairing this panel today because I've worked with nearly everybody in the panel today, working very closely on our Illegal Migration Act challenge, and I know they're really dedicated and very, very well-informed panel members, so we're really in for a treat, I think. So I'm going to be introducing everybody and just doing just a quick introduction on their background, but we're going to be looking at the legal aspects of asylum protection in Northern Ireland as part of this panel discussion. So I'm delighted to be joined by Liz Griffith, Maria McCloskey, Anne-Marie White, and Israel Eguaogie. So Liz heads up the Migration Justice Project at the Law Centre. Outside of this work, she's a trustee of Flourish, which supports survivors of human trafficking and volunteers with the Belfast Friendship Club. Maria is the director with the Public Interest Litigation Support Project. Prior to joining PILS, Maria was an immigration solicitor at the Children's Law Centre, where she represented unaccompanied asylum-seeking children in their asylum and trafficking claims. Maria is also the author of the Best Practice Guide in the Provision of Immigration Advice Services in Northern Ireland, and is a former chair of the Law Society of Northern Ireland's Immigration Practitioners Group. Anne-Marie has worked for the Red Cross for over 5 years, managing refugee support operations in Northern Ireland, including asylum, destitution, refugee resettlement, and family reunion. She has extensive experience in refugee integration and managing EU refugee integration and peace-funded projects in Northern Ireland. Anne-Marie's work combines operational service delivery, advocacy, policy, and public affairs, focusing on a rights-based approach. Israel is a development manager with Belfast City of Sanctuary. He brings a wide range of expertise to this role. He's co-founded and chaired organizations including the Nigerian Community of Northern Ireland, Diverse Youth NI, I Assist NI, which is a befriending charity organization with the core aim of reducing isolation and improving the health and well-being of individuals living with long-term illnesses and disabilities. He also chaired the Belfast City of Sanctuary before taking on his present role in 2022. So firstly, if we can start with Liz. Liz, can you give us your sense of the key issues in the operation of asylum policy in Northern Ireland at the moment?
Yes. From here, or my...
Yep. Do you want to?
Yep. Great. Well, thank you very much, everyone, for this opportunity, and thank you, Alison, for the report. I can assure you we will be reading every line very closely back at the Law Centre. And for those of you, I hope you're familiar with our work, but if not, we are a charity. We seek to promote social justice using the law, through the law. We work in different areas of social welfare law, including immigration. And within our kind of immigration work, we have the Migration Justice Project, which I lead, which brings together our community engagement, policy, and legal. We are extremely busy. Just this year, to give you a flavour, we've assisted over 400 people and their family members on top of that to secure status. We've got about 170 cases on the books at the moment, with cases pending before Home Office or tribunals or the higher courts. And so one of the reasons that we are so busy is, you might be aware, there has been a really significant increase in the number of people seeking sanctuary in this jurisdiction. 2 years ago, in June 2021, there were about 800 people. 2 years later, there were over 3,000 people, close to 3,500 people now, seeking sanctuary. Now, we want to be realistic about this in the grand scheme of things. Compared to Lebanon, for example, we are not hosting many refugees, but as an increase here, it is very significant. And one thing I can tell you for sure is, while the number of people seeking sanctuary has trebled, there hasn't been a similar increase in the number of resources coming to the support sector. And you will hear about the impact of that on legal, on health, and all the support services. So the numbers alone make this a challenging space to work. But very quickly, I would like to list a couple of other challenges that we as a sector are experiencing. And one of the big challenges is, of course, we know that international human rights law places a duty on states to develop effective measures for refugee reception and refugee integration. And this duty sits with the Executive Office, which since 2005, 18 years ago, since 2005, have been committed to drafting and implementing a refugee integration strategy. So whereas Wales and Scotland have a strategy, we have a draft, and it has been in draft for 18 years. And without such strategy signed off, we do not as a sector have a clear shared understanding of what effective integration is. So I feel that we're basically muddling from one thing to the next. The Syrian resettlement scheme has come and gone. And we still don't have a clear, kind of coordinated approach. So that is a challenge. Should say that this time last year, the Executive Office set up a new division to work on refugee integration. And of course, we welcome that. That is a very welcome, if overdue, development. But until we have a strategy, a division is not enough. And in the absence of a government strategy, the Law Centre, through the Refugee and Asylum Forum, which we convene, we've put together our priorities for action. I say 50 organisations, civil society organisations, have contributed to this. And if you are a policymaker in this room, or you have influence over a policymaker, I would ask you to take one of these. Because, as I said, in the absence of government policy, this is the blueprint, as the sector sees it, for what needs to happen. The other challenge I'd like to flag, of course I have to, is the spectre of the Illegal Migration Act, which has already caused so much distress to our clients. And one of the requests that we as a sector has put to the Executive Office is to assure us that, as best as they possibly can, to ensure that public services will still be available, critical public services for asylum seekers. if the Act is implemented. As Alison said, they might not be asylum seekers. They will be people in limbo who haven't been able to lodge a claim. And being an asylum seeker at the moment, it doesn't give you many rights and entitlements, but it does entitle you, for example, to free healthcare, free school meals. So we need to be sure that if that Act is implemented, people in the system will have access to those critical public services. And that is something that the Executive Office could audit and ensure that the legislative and policy framework is tweaked to ensure that. The third challenge that we see is the fact that Northern Ireland is the only jurisdiction that does not have a strategic migration partnership. I know this might sound very bureaucratic, but the strategic migration partnership brings independent oversight of the work, and it also plays this key function in promoting coordination from government, local authorities, councils, and civil society organisations. We don't have one, and particularly in current context where we're seeing really over the last 2 years, asylum seekers are being moved to cities outside of Belfast. Now, more than a third of asylum seekers in this jurisdiction live outside of the capital. So this would be, we really need that coordinating role of the Strategic Migration Partnership, and yet we don't have one. I will stop there. Thank you.
Liz, thank you so much, and I think we'll all agree that's a really passionate sort of plea for more resources, more help, and more coordination within the sector, because it affects so many people. As Liz has said, there's thousands of people wanting to claim asylum, and their applications are just being held up in the system. I'm just going to turn to Maria. Maria, your work focuses on a related aspect of the asylum system in providing support to lawyers in the field. As a lawyer myself, I understand and have been speaking with many practitioners the difficulties they're facing in terms of actually just getting out there and providing those kinds of services and advice, just because of the pressure on legal aid services and just the number of solicitors that are available to do that work. Could you just give us a bit more information on that aspect?
Yes, sure. Thank you, Ty, and thank you to the Commission for inviting me onto the panel today. So my name is Maria. I am here representing the PILS project, which is the Public Interest Litigation Support Project. Our organisation was set up to tackle the knowledge and financial barriers to strategic public interest litigation in Northern Ireland. And so we are a membership-based organisation made up of solicitor firms and NGOs who wish to advance public interest litigation that engages a human rights or equality issue at the heart of them. So obviously we are supporting solicitors, firms and NGOs working in this sector in many of the challenges that they are facing, particularly over the last couple of years. But we know from our close work with the Immigration Practitioners Group that we are talking about a crisis of representation, and we have been talking about a crisis of representation for actually a number of years now, not to mention the current onslaught of challenges, because I think that's exactly what it is. And so our practitioners, who are dwindling in number because of the fact that mainly the legal aid rates in relation to immigration and asylum have not increased in over 20 years. And so that makes it very difficult for private practices to be able to support this type of work. And at the minute, there is an ongoing review of civil legal aid. Immigration and asylum was not originally included in the remit, but thanks to the hard work and dedication of those in the Immigration Practitioners Group, they are becoming involved in that review and have sought input into that to feed back to the Department for Justice. So obviously, having faced that crisis of representation over the last number of years, as I say, we're now facing the challenges that exist because of the developments in legislation. And as Alison mentioned earlier about the limbo that is going to be created. Ultimately, those who have arrived, particularly this year, from the 20th of July, are in that limbo at the moment, because we're pretty certain those cases are not going to move on until the government decides what it's going to do. And for anyone going through the asylum application process, it was always a horrendous process to have to go through. And I can't imagine what those clients are going through at the moment, not knowing what is going to happen to their claims. They have no idea. And the solicitors who are trying to advise them through this process have no idea either. So that has made it just such a difficult environment to be trying to provide legal advice services. And I suppose I can speak to what PILS is trying to do to support those firms and NGOs in this area. So at the start of this year, PILS as an organisation set a number of strategic priority areas, one of which was challenging the hostile environment. And last year we received 4 applications for support in relation to immigration and asylum matters, and that has effectively doubled to this date so far this year. So, I mean, we receive applications for support across the range of our services, which go from financial support right through to training, education, and we also have a register of pro bono lawyers who are willing to provide of their services free of charge, and we've had to rely very heavily on that this year, as you can imagine. But we've also, even though we don't have a policy and advocacy role, we've tried to step into that a little bit with the Illegal Migration Act, because we see it as a strategic priority area, and ultimately we need to know what's happening and keep up with what's happening. And my colleague Hilary, who is here today, has been working very closely on this this year, having contributed to briefings, a joint briefing with the Human Rights Consortium, and also Liberty's briefing on the UK-wide impact of the Illegal Migration Act. So obviously then we have this new legislation, and what we think it will mean if it continues and if the government tries to find a workaround and is subject to further challenges. Effectively, it wipes out the asylum application process. It creates a new system for making claims in respect of a limited number of applications, but the time limits for those are so tight that, as anybody knows working in this sector, even getting a solicitor, you probably would be out of time for making some of those claims. But what we're doing is finalising a fact sheet in relation to those suspensive claims. And as I say, we're here to support in whatever way we can. Ultimately, as I say, we are about the strategic approach, and we would encourage anyone who maybe isn't a member of PILS that is in the civil society sector that would like to come to us or at least find out what we can do. We would love to hear from you today or after today. And one of the other things that we've developed this year is a country of origin information report project, whereby we can provide reports to solicitors who maybe don't have the capacity to do that research to support claims, that we can do that through our project. And again, I can provide any further information on that afterwards. So I'm going to stop at that point too. Thank you.
Maria, thank you so much. Anne-Marie, so access to services is also the other part of the jigsaw, and I know Red Cross is engaged in this work. Could you tell us more just about the issues or the challenges that you're currently facing?
Yes, thank you. I'll talk more today really about the implications of the Act and also the practicalities, what it might look like on the ground. I think often the lived experiences of people are not often heard. And although I'm here today without lived experience of an asylum process or displacement, over 60% of our team does have that. And we have different forums within our work that ensures that people's voices and their experiences are heard. So that's really important to set out the information that I'll be providing today. You may be familiar with Red Cross, International Red Cross, all across the world. I won't talk about that in any sense. I want to talk really about what we do in terms of refugee support in Northern Ireland. as we're based in Belfast, and we have a range of different services. Within our team, we have 9 different languages and different cultural nuances that we work within as well. So we're really lucky with lived experience, language, and also that cultural competency within our team. Helps us to really develop and work in a way which is very well informed. Within our team, we work with a range of people from newly arrived asylum seekers, people unfortunately may be destitute or refused, provide very practical support in terms of complex casework, as well as practical support, we administer the Executive Office Crisis Fund. So along with casework, it allows some very practical elements of supporting people. And again, we look at reunited families. We ensure that we support people to be reunited within the framework of family reunion visas, as well as a particular Ukraine response as well. So within that, there's quite a lot of work, as you can imagine. Everything is complex. There's no such thing as somebody would call looking for one particular thing. So the orientation integration might lead into looking at the asylum system. Once you start scratching, you'll find that almost everybody has challenges and issues. So going in, just giving a workshop or having a conversation is never like that. And therefore it evolves. It gives us a really good evidence base as well, of which to advocate singly and as groups for people, which is really difficult to have because we're so busy firefighting in this sector that providing that evidence base to really have a good advocacy base or lobbying is really missed, I think, within our sector. Just to give you an idea of just last year, we supported around 2,500 people within our service. And within that, there are over 10,000 actions. These are casework actions. So it's significant. So when we think about another change to an already very challenging immigration process, trying to navigate that, and this is what we do every day, for anybody trying to navigate that, even within our team, is really challenging. Things are changing, processes are not followed. So we're constantly trying to piece together and navigate, as well as providing a person-centered, trauma-informed response. And that's really challenging as it stands now as business as usual with the Home Office, with the current immigration rules. To think about this changing and us not really knowing what's going to be happening in the next few months is even more challenging, almost overwhelming. And that's for us who feel as though we are fairly equipped and we're agile. But for other people that are not within our sector working, who are in the throes of having arrived after the 20th of July, people still believe they're in an asylum system because the current process of asylum intake is exactly the same as it was before the Act was passed. So it's really unclear for people at the moment, which is really challenging. We've been working with inadmissibility for a while, and an inadmissibility team, a third country team within the Home Office. But we always knew that after 6 months, these third countries were not going to accept anyone back. So it was kind of like an administrative process. So we knew that was going to be happening. And then people continued along the substantive casework. We're unsure of what's happening at the moment. And that's really challenging for us to be able to provide advice and support, but also for people who are going through. And misinformation is rife, absolutely rife. When there's lack of information or there's nothing coming from our Executive Office and the Home Office haven't worked out their operational plans, then misinformation will fly. And that in itself is really worrying. So just in Belfast alone, with one particular advice centre or advice service we have, between May and October, we had 500 people just wanting help. And this is people currently in the substantive casework. So they're in the process. There are always challenges and issues. And this takes a lot of resourcing and a very hard resource to sustain. So without that resourcing, we have a lot of people who are not being supported. And there aren't always, within the contracts that currently exist within the Home Office, quite high-value contracts by profit-making organisations. The two main contracts, they're not there to advocate. They're there with their KPIs to follow out a process. So there's a massive gap of advocacy and support, which these contracts will not fulfil, which lends me to some concern as to within these contracts, there is nothing there for people who are illegal, deemed illegal. So currently within these two contracts for advice and support and accommodation, those contracts are there for people who are coming through an asylum intake process. And as we are in mid-November, there is nothing that has been changed or amended in those contracts. So the big question is, where does the support lay? Where does this sit within these government contracts? Where does it sit within the Home Office processes? And that's really worrying. Nothing happens very quickly in terms of legally binding contracts changing, and nothing has happened as far as we know. That's the absence of knowledge that we have in the sector, and we have from the Executive Office. There's nothing that's coming our way to help us prepare and resource for such. Just to give you an overview of the current state of the nation, there's a report the Red Cross have completed recently around the state of the nation. So people seeking asylum in the UK make up less than 7% of the 1.16 million people migrating to the UK in 2022. If you talk to people on the street, people often think that asylum seekers are really overwhelming the immigration practice and process. At the end of June this year, there were almost 100,000 people who'd applied for asylum in the UK. In the same period, only 905 people were settled here safely. So the Act talks very much around safe legal routes, and everybody in this room on this panel would agree that we would all support safe legal routes. The government commended themselves with the Syrian resettlement scheme, how well, and again with the Ukraine scheme, and now with the Afghan resettlement scheme. We really welcome that, the level of support and the responsibility and accountability that had. People arrived with their status for both of these resettlement schemes. There aren't the resettlement schemes there. In 2019, I think the UN stated that they assessed 1.4 million people who were displaced and registered with them as being eligible for resettlement. In that same period, 68,000 people were resettled. So as much as we talk about safe legal routes, we need to be practical and provide them. No one can claim asylum outside of the UK. So again, in the last 12 months, in the last year, there were less than 5,000 family reunion visas, another safe passage for people. And they were granted in the last year. That's the lowest number of visas granted in this 12-month period since 2014. We're moving away from safe legal passages for people to be reunited. We're not improving on that. The asylum backlog at the moment for people waiting on asylum decisions is 175,000 plus. So if we have this backlog of people and we have this new Immigration Act coming into play operationally, legally, we're not really at a very good starting point. And we know the Home Office introduced a streamlined asylum questionnaire, which came out of the blue. And I have to say that at the end of last year, ILPA, Red Cross, we all had a consultation with the Home Office around potential for some kind of streamlining or questionnaires. And it wasn't actually feasible because the Home Office were basically asking solicitors to do a substantive interviews. And that's what's happened. Out of the blue, one evening, people started to receive streamlined questionnaires. And whilst we welcomed more decisions being made and that being extended to more countries, there's immense pressure on immigration practitioners to complete these questionnaires, and at risk of people who are not regulated to complete these and get in trouble. And nothing is translated, as we know as well. So in 2014, we're working under a new asylum model, which was a 6-month asylum decision-making process. So in 2014, 9 out of 10 people who applied had a decision within 6 months, which is pretty good. Now, only 1 in 10 had their decision within 6 months. So people are sitting in limbo for long periods of time. And that, of course, was where people were going into the third country teams for 6 months as well. So I'm giving you the state of how things are currently, which is not good. And we're thinking about coming into a new system. It's very worrying. And in the last year, 38% of asylum claims were withdrawn. This is something which has really increased by 308% since last year. This is a very worrying and new thing, really, in Northern Ireland as well that we're seeing. And as Liz mentioned, there's over 357% increase in asylum intake in Northern Ireland compared to other devolved nations of Wales 3% and Scotland 14%. We don't have the resources to manage that. And I think the IMA has really come out of the increase in people arriving in small boats. In 2018, there were 288 people who arrived in small boats. At the end of October, there was over 111,000. And I think that's where the responses really come from the government, who talks about stopping small boats. So given the current state of affairs, given the current asylum system, the operational inconsistencies that the Home Office have in their working and the contracts that are being operational, it's really difficult to try to navigate to support someone to come through a process of which there is guidance and policy within the Home Office. Trying to navigate when we don't have any guidance or policy will be impossible, absolutely impossible. There are so many issues with formal notifications, with Home Office departments not really talking to one another, that we're constantly at a loss, and each case probably takes 10 times more than it needs to take if we knew what processes were supposed to be followed. So yeah, we're not able to resource properly. The Red Cross have a Voices Network, and when we first spoke with the Voices Network about, the Nationality and Borders Act, would this stop people from coming in and seeking asylum? Categorically no. People need protection, This is punitive. It won't stop people from trying to seek a safe place or seek protection. Liz mentioned very much around the resource. I don't want to go on about that too much. I want to talk a little bit just around the dispersal of asylum seekers across Northern Ireland, which has never happened before. We have no dispersal policy within Northern Ireland. So council areas that are taking in, so to speak, people in the asylum estate of accommodation have never done this before. There's no guidance, there's no asylum policy developed by the Executive Office. So therefore, every area are doing things differently. Every area for the first time this year are really working with people seeking asylum. It's really worrying to think what's going to happen come an Illegal Migration Act operational happening there. So that's just a concern here, and just the lack of planning and the lack of comms, and the pressure on online frontline services as well as immigration practitioners. So yeah, I think that's probably enough. I can see you looking at me. I'm not known for being very short when I speak either, or very succinct. So thank you.
Thank you so much, Anne-Marie. That was really informative. I'm just going to turn to Israel now. Israel, your work brings you into close contact with individuals facing enormous difficulties under the current policies. We know just from people that have approached the Commission, there are a lot of people who are individually affected through mental health difficulties because of trauma that they have faced fleeing their countries of origin, but then also arriving here and adding to that trauma because the decisions are taking too long, or problems with dispersal accommodation. Can you just give us a sense of the impact at the individual level?
Thank you very much. My name is Israel Eguaogie, and I am the Development Officer for Belfast City of Sanctuary. We work with other organizations and Belfast City Council to promote the culture of welcome, safety, and inclusion. Over the last couple of years, we have worked closely with about 62 schools with additional 8 schools to achieve the School of Sanctuary Award, with other streams like the Library of Sanctuary. The first Library of Sanctuary is the Alma Road Library, and we also have the first College of Sanctuary, which is Belfast Med. However, the council has agreed unanimously, it was unanimously agreed last year that Belfast should officially be declared a city of sanctuary, but then there's still some legality and procedures to achieving that. That's where we are soliciting to other organizations to join in this campaign for Belfast to be declared as a city of sanctuary. But then you clearly highlighted some of the challenges associated with access to resources. And one of those areas that I'm going to talk about is access to healthcare, with practical examples from 2 case studies from 2 families that I've worked with. FH, let's assume her name is Fatima. Her son is 13 years old and has been in trouble several times in school for behavioral issues. I've had the opportunity to attend about 6 of those meetings in the school where the teachers constantly complain that he is very boisterous and won't sit still. So he would go on suspension on numerous occasions. The last meeting that we attended, I advised, have you sought medical attention for this young child? If you clearly state as a teacher that whenever he comes to school, he will always draw up or provide drawings of decapitated bodies, probably these are the things that he was exposed to. And he's practically showing it to you that he's carrying trauma. Should this child not be assessed? So the school said that's not within their remit, but they can definitely refer the child on. And on one fateful Friday, the mother called me and said the child wrote a note and left it. And this is what the child said. It said, I am sick of life and do not wish to live anymore. A 13-year-old boy. And I advised the mother to call a GP, which she refused, that probably that's going to affect the asylum claim. So there is the fear upon fear. So this is just like a rolling cycle. The mother is also traumatized. She's a single parent with 3 kids. They are at a limbo where they do not know what's next. Within the last 9 months, prior to that letter, there was no information from the Home Office, not even the solicitor, so they don't know where to turn to. And the fear because of misinformation that if you report such cases, it to have effect or impact on your asylum case just made her to close up. And whenever I called her, she refused to take my call. I was just trying to help. Another case study here is about SM. She's been attending the A&E for over 9 months, close to 10 months, complaining of her hip pain, and she will always be sent away with paracetamol. I think the last time she got referred by her GP to physiotherapists due to the pain, the physiotherapist said, and I quote, I will not touch this pain because it needs to be seen by an expert. And he referred her for a scan. And it was after the scan, after 10 months, that they realized that she has a tumor on her hip. On the 5th of October, she was rushed to the hospital by an ambulance, and they still wanted to send her back home. However, the father of her child resisted and insisted that this woman should be scanned because she started complaining of her back pain. And it was after that scan that they realized that she has cancer in her lungs, cancer in the liver, cancer in the throat, cancer in the stomach. So the cancer had spread. But just think about it, 10 months ago is a long time. So whereas we have rights, we could actually attest and read that access to healthcare is human right. But what plays a role in depriving certain individuals of those rights is discrimination, gatekeepers, and being an asylum seeker, the fear of even asking for help. Over the last year, I've had 120 phone calls, triaging individuals, signposting 16 people to political representatives. Kate Nichols' office is present here today, and they can attest to that. And the numbers just keep rising, be it access to healthcare, access to housing. This case keeps rising. And whereas we've talked about mental health and cancer, there are other illnesses. And I've talked about asylum seekers. Now I'm going to talk about myself as a case study. Upon arriving here, I wasn't an asylum seeker. I migrated from Germany down here. Having worked for a couple of months, I fell ill, went to see my GP. And he said, and I quote, "You were here last week and the week before. If Northern Ireland is not good for you, why don't you go back home?" Those were his words. And I asked him, where is home? Yeah, wherever you come from. That was a direct statement. And I decided to change my GP, but at a point I stopped. If I keep changing GPs and it keeps happening, I will run out of GPs. So I'd rather stay with this guy and he will continue to see my face for the rest of his life. But so many people don't have that capacity to do that. That's why I got over 120 calls. Can you recommend a GP? The GP said this. The GP wants to see me, maybe because I'm a Muslim, maybe because I'm etc. So cultural awareness is another key factor here, because some people from different cultures may not want to see a male GP due to X, Y, Z, and that's the case of another lady called Maria, for instance. She was diagnosed with breast cancer. Because her GP was male, she couldn't tell her GP what she was feeling. So she was hiding it, she couldn't complain until her friend, who knows another nurse, complained to the nurse, this is the pain that this lady is feeling, and they had to feel the breast and found lumps everywhere. So those are the certain challenges that most people seeking asylum, not just asylum, but seeking sanctuary faces. I think I'll raise my mic for a while. Thank you.
Israel, thank you so much, and thank you for sharing your story with us. That's very powerful, and the case studies that you gave us, they're really shocking and quite hard to listen to, but unfortunately they're not isolated instances. Our panel members will contest to, and I think you've raised that cultural issues and lack of cultural understanding is a real issue that policymakers here, I don't think, are aware of. I was hoping to ask some questions for the panel members, but we have run out of time, but I think they've been so fulsome in their presentations and their stories that I don't think we really need to add anything extra to that, or whether we can actually take any more at this stage. So the time's now, it's just gone past 3:30, and we're now going to be doing some table discussions. So
we have 5 minutes just before I draw this to a close. I know you've all been busy talking away with each other. So I'm just going to offer an opportunity for a bit of feedback from each of the tables. But I'd ask whoever is going to speak on behalf of each tables to keep it really brief. So I'm going to start at the back.
Could somebody give you a mic as well before you talk?
There we go. Oh, there we go. So we'll start at the back table.
Thank you, David. Yes, just very quickly, we had some really interesting discussions at our table. We talked about the standardisation of hotel provision and making sure that those contracts adhere to human rights standards, including around food and children's rights specifically. We talked about how the refugee integration strategy isn't progressing, and we give a couple of reasons as to why, one of them being the absence of government, although it was raised at our table that we have the Executive Formations Act that we could maybe use to encourage that to be pushed forward. And then we talked about how to tackle misinformation in asylum and refugee-seeking communities through going specifically to the community and directly teaching people about their rights, and going to different communities with different languages and bringing people to speak to people in their own language. And we also talked just about the sort of horrendous racism and discrimination that people face in healthcare settings. I think that's us.
Thank you. And could I go to the back, to this table? Rihanna, the back.
Thanks, David. I think, again, we talked about the process. That was frustrating. It was longer than it needed to be. There was a lack of information for individuals, for lawyers. That brought in issues about access to translations, and then the difficulty of misinformation, concerns around exploitation of people who will find themselves within this system. And we were heartened to hear Anne-Marie's comments about how it's not going to stop people coming. You know, the IMA will not stop, and we have to look at how those people are going to be protected here. We talked a little about the UK rhetoric around immigration. Anti-immigration rhetoric was probably already here, and we can see signs of that even in previous weeks. Then the fact that everything we've heard today has been negative and that we really do need to reframe the conversation to think about the positive contribution that asylum seekers and refugees have within our society. We also talked a little about kind of comparative, looking at Colombia and how it has hosted refugees from Venezuela, how it brought in a temporary protection system with a view to moving to something more permanent. And also finally that despite the concerns with delays, individuals not being within the formal systems really does chip away at other rights. So we tried not to, but unfortunately we did have to start thinking about health, education, housing and social security, and how we couldn't distinguish between the formal process and impacting on rights and other human rights.
Thank you. Eilish?
We had an interesting discussion, mainly highlighting that the IMA will scrap the new asylum system, so that would be very difficult to start to understand something that we didn't understand to begin with. There's also, we talked about the higher number of refugees and asylum seekers coming in, the lack of resources. We did talk about some positive aspects of the Rwanda judgment, for example, that highlighted the importance of international law and customary international law, which is kind of a positive somehow step. Also, we have underlined the fact that the Rwanda and the IMA are both two things that were never practical to begin with, as Rhiannon have pointed out. We also all agreed that there is an immense lack of clarity when it comes to the asylum and immigration rules, which I think maybe the next steps we could think about would be put more pressure on the government to offer more clarity about how the processes in Northern Ireland are carried out, and how that would mean when it comes to the new legislation that we have.
Thanks, David. So we discussed very similar themes to everybody else, and we were really sort of very impressed with Israel's panel discussion, just in terms of the individual impact it had, and it really affected just the way we think about asylum seekers in general, and having that sort of personal account of how the difficulties that people are facing. We also just discussed that nothing has really changed in the last few years in terms of improving access to services and getting decisions for asylum seekers. We also discussed just in terms of some constitutional matters. So just the flip side of what Colin had said was, is Article 2 sustainable, and the fact that it's encroaching on Westminster's powers. Whereas the flip side for us is it sustainable that Westminster is encroaching on devolved powers, because the IMA makes wholesale changes to trafficking provision protections and civil legal aid, which are devolved matters. And also we just discussed just the importance of Article 2 going forward for all the governmental departments in terms of ensuring that policies and decisions are made in compliance with Article 2.
Thanks, Di. And Claire, is there anything online? Or?
We had an interesting discussion about non-recourse to public funds and how that overlaps with violence against women and the domestic violence exemption, and some of the other discussions here today. Thank you.
Thanks, Claire. Okay, so I'm eating into your time. I'll keep this brief. On behalf of the Commission, I'd like to thank all of you for coming today and contributing to such a good discussion. Not least, in fact, everything that's been said, of course, will feed in and assist the Commission with its own motion legal challenge on the Illegal Migration Act, which all of you will know a lot about already. I'd like to thank Alison in particular for her research, along with the reports and opinions by other legal experts and academics, and it's helping us and the team led by Alyson in terms of setting down a solid foundation for this particular work as part of the dedicated mechanism. To our panellists, to Liz, Maria, Anne-Marie and Israel, my sincere thanks as well. It would have been remiss just to focus on legislation and policy without hearing about the real world examples and what it actually means and impacts on the ground, because at the end of the day, that's what the work of the Commission is about, making rights real. And to Alan, thanks a lot for your technical support and wizardry for the afternoon, and to the colleagues at Clifton House for hosting us. As was mentioned briefly earlier today, this is part of an ongoing research programme of the dedicated mechanism through the Windsor Framework, Article 2. We've recently launched work, for those that aren't familiar already, on frontier workers. So Sylvia de Mar's project and Charlotte O'Brien. And last year saw a piece by Tammy Harvey on access to healthcare, and by Alison, as she mentioned, on human trafficking. Colleagues at the Equality Commission who've joined us today have also an extensive programme of their own, and we're working together, and we're coordinating work across the island with the Irish Human Rights and Equality Commission on the all-island aspects of the work of the dedicated mechanism and rights after Brexit. And for everything that's been said so far, I mean, you shall be aware there's already been some positive early judgments with regards to Article 2, and there's much more in train to be ruled upon by the courts. In March then, looking ahead, so next year, starting in March, the team are going to be launching a piece of work on the enduring impact of the EU Charter of Fundamental Rights in Northern Ireland. And then later again in the year, we're looking particularly at the aspect of environmental protections and environmental rights, and we're going to be launching a piece of research on the intersection of Article 2 with that particular issue. We're looking forward, as ever, for those that have attended these events before, to continuing the conversations with yourselves. It's really valuable to the work of the Commission, getting your expertise. You have helped us identify issues today already, but if you identify anything else, particularly in regards to this piece of research, but generally with regards to the programme of work around the Windsor Framework Article 2, please get in contact with Alyson and the team at the Commission. We'd love to hear from people. It's a huge piece of work, massive. The scope of it is yet to be determined, to be quite honest, in many ways. And the more brains that are put to this particular aspect of our mandate, so much to the better. Finally, Alyson's given me a note. It would be remiss of me not to say, please everyone feel free to join us on the 11th of December at Stormont, and if not, online, for the Commission's annual statement, our State of the Nation so-called human rights work. This year we're delighted. It's Mary Lawler, the UN Human Rights Special Rapporteur on human rights defenders. And finally, please fill out your evaluation forms and let us know what you think. Thanks very much.